Hello, bonjour, Tansi. I'm Sunil from the Family Law Information Center. In this video, we will talk about terminology used to describe parenting arrangements, types of parenting arrangements, how parenting arrangements are enforced, safety issues, and where to go for further information or help. In early 2021, the terminology for parenting arrangements in Saskatchewan is changing. The terms custody and access are being replaced with the terms decision-making responsibility and parenting time. The intent of this change is to emphasize the best interests of the child and focus on relationships with children. Decision-making responsibility may still be referred to as custody in some places in Canada. In other places, it may be called parental responsibility or guardianship. It is the right to make significant decisions about a child. These decisions include things like where a child will go to school, where a child will live, what medical treatment the child will receive, and if a child will participate in a religion. The most common types of decision-making rights are sole or joint. A parent with sole decision-making rights can make all of the significant decisions. When parents share decision-making responsibilities, the parents must communicate and discuss issues and make decisions about the child together. Saskatchewan law sets out guidelines about how decision-making is divided when there is no agreement or court order in place. It says that in situations where the parents live together with the child after the child was born, the parents share decision-making responsibility. If the parents did not live together after the child was born, the parent that the child lives with has sole decision-making responsibility. These determinations of sole and joint decision-making are the default, but they can be changed by agreement or by court order. The term parenting time refers to the right of a child to have a relationship with a parent or caregiver, and at a time the parent or caregiver has the child in their care. Parenting time replaces the term access, but the terms access or contact may still be used in other provinces. The term parenting time refers to the right of a child to have a relationship with a parent or caregiver, and the time a parent or caregiver has the child in their care. In Saskatchewan, parenting time replaces the term access, but the term access or contact may still be used in other provinces. All decisions about children, including parenting arrangements, should be based on what is in the individual child's best interests. This is a legal requirement that is set out in Saskatchewan legislation, federal legislation, and the UN Convention on the Rights of the Child. There are several factors to consider when determining what is in a child's best interests. They include the quality of a parent or caregiver's relationship with the child's personality, character, and emotional needs, the child's physical, psychological, social, and economic needs, the parenting capacity of the person seeking the order, proposed future home environment for the child, and future plans for the child. The wishes of the child should also be considered to the extent that it is appropriate, based on the child's age and maturity level. Generally, the wishes of older and more mature children will be given greater consideration than those of a younger child. Family violence should also be taken into account when looking at a child's best interests. For example, a parent's use of violence to control situations may affect his or her ability to focus on the needs of the child. Parents should learn about their rights and responsibilities under the Children's Law Act and Divorce Act before making decisions about parenting arrangements. As well as watching this video, you can find more information online at the familylaw.pli.org website or the justice.gc.ca website. At any time, parties can come to an agreement about parenting, including any aspects of decision-making and/or parenting time. Parents can even agree that someone else, for example, grandparents, step-parents, may have decision-making responsibilities, which is custody, and/or contact, access. For those interested in making their own parenting agreements, self-help kits are available through the Family Law Information Center, and there is an agreement maker at familylaw.ple.org. Justice Canada has information about creating your own parenting plan at justice.gc.ca. If parties can't negotiate on their own, there is assistance available. For instance, you could consider using the services of a mediator, parenting coordinator, collaborative lawyer, or family arbitrator. For more information about which services might be right for your family, you can contact the Family Matters program by calling 1-844-863-3408 or by emailing familymatters@gov.sk.ca. You can visit the Saskatchewan.ca website and search for Early Family Dispute Resolution, or you can watch the options for resolving disputes video in this series. If an agreement is not possible, a parent can ask for the court to determine the appropriate parenting arrangement, decision-making, and/or parenting time. Any parent of a child can apply for decision-making and/or parenting time with a child. Other people who have a close relationship with the child may also apply for decision-making responsibilities or parenting time. People, other than parents, need to show the court that they are a person of sufficient interest in relation to the child. This could be someone like a grandparent or a step-parent who have spent a lot of time with the child. Legislation that directs how decisions are to be made by the courts is found in the Children's Law Act and the Divorce Act. Married parents can apply under the Divorce Act or under the Children's Law Act. Unmarried parents and persons of sufficient interest can apply under the Children's Law Act. Courts must make decisions about parenting arrangements based on the individual child's best interests. There are many remedies set out in the Children's Law Act to encourage parents and anyone else with decision-making responsibilities to follow the terms of a parenting agreement or a court order. These remedies include orders restraining one parent from harassing the other, a clause preventing one or both spouses from removing the child from a specific city or province, an order to surrender passports or travel documents, compensatory or make-up access time, posting a bond, supervision of parenting time, appointing a mediator, varying the parenting order, or having the party who is not complying with the order found in contempt of court. Interpersonal violence and abuse refers to violence and abuse that occurs between people who know each other. This can mean physical violence, but it also includes situations where a person is causing feelings, such as fear, anxiety, nervousness, guilt, helplessness, worthlessness, or tries to gain control over another person. It can occur within or outside a family setting and before or after the end of a relationship. If you think you may be or may have been in an abusive relationship, it is important to make sure you are safe and supported before you make any decisions about parenting arrangements. All immediate safety concerns should be reported to the police. There are also programs, support services available to help. To learn more about these programs, visit Saskatchewan.ca and search for family violence. You may also want to talk to a lawyer. There are other remedies a lawyer can help you with. These include applying under the Queen's Bench Act or the Children's Law Act for an order that a person be restrained from harassing or communicating with the applicant or child in the applicant's care or custody. Applying under the Family Property Act for an order that a spouse not attend at or near the family home. Or applying for a peace bond under the Criminal Code. If you have concerns about the safety of a child, you are required to report it. Reporting concerns of child abuse or neglect is everyone's responsibility. Safety concerns should be reported to police or the Ministry of Social Services. For more information on how to make a report to social services, visit saskatchewan.ca and search for child protection. If you would like legal advice but can't afford to hire a lawyer, you can apply for legal aid or a pro bono lawyer. Another option is to consult a lawyer who provides unbundled services. Unbundled legal services means you hire a lawyer to do specific tasks and only pay for those tasks, and you do any other work that needs to be done. A list of lawyers who offer these services is available on the Saskatchewan Legal Coaching and Unbundling website, www.sklcup.com. If you have any questions about parenting arrangements, contact the Family Law Information Center by phone at 1-888-218-2822, extension 2, or by email at svp@gov.sk.ca.